Thank you so much to everyone joining us here, whether you're joining on Zoom or joining us through our YouTube live stream. I really appreciate everyone being here. I'll give some just very brief opening logistical remarks and introduce Vinnie Schiraldi, and then we'll jump right in. So I'm Kendra Bradner. I direct our probation and parole reform project at the Columbia Justice Lab, and I'll be your MC for this afternoon. I'd like to share just a very brief but also very sincere thank you to the co-sponsors of today's event. So Amore Just NYC, the New York State Bar Association and its task force on the parole system, and the American Bar Association's criminal justice section. A special welcome to folks who found your way to today's conversation through one of those groups. I'll turn it over now to Vincent Schiraldi, who's co-director of the Columbia Justice Lab, to introduce today's keynote speaker. Go ahead, Vinnie.
Thank you, Kendra, and welcome everyone. I'm really excited today has come and that we're able to partner with the Independent Commission, State Bar Association, and the American Bar Association's Criminal Justice panel on today's important event. New York State is to be embarrassed by our work in parole, both by how many people we return to prison for technical violations of their parole, but also by our failure to help them when they return home from prison, thrive and live the kinds of life we want for anybody we'd want for our own son or daughter if they were returning home from prison. And hopefully today's panelists will do much better job of discussing that than I have. But it's at my absolute pleasure to introduce the Honorable Jonathan Lippman, former Chief Judge of New York and Chief Judge of the New York Court of Appeals, the state's highest court. He's of counsel in the New York office of Latham and Watkins, and he served as Chief Judge from 2009 through 2015, where he championed equal access to justice in New York and around the country, and took a leadership role in identifying permanent funding streams for civil legal services. Judge Lippman made New York the first state in the country to require 50 hours of law-related pro bono work prior to bar admission, and established the pro bono Scholars and Poverty Justice Solutions programs to help alleviate the crisis in legal services for the poor. In the criminal justice arena, Judge Lippman strengthened the state's indigent criminal defense system, addressed the systemic causes of wrongful convictions, created human trafficking courts across New York State, and led efforts to reform New York's juvenile justice, bail, and pretrial justice system. He's presently, as I mentioned, chair of the Independent Commission on New York City Criminal Justice and Incarceration Reform, which is co-sponsoring this event with us. They have been leaders in efforts to close the Rikers Island jail. Don't know if folks out there know it, but I've been named this week by Mayor de Blasio to become Commissioner of New York City's Department of Corrections. So I will now be picking that report up, rereading it, dusting it off, and trying to implement as much of it as I can in the time I have allotted to me. So I want to just thank Judge Lippman and turn it over to him. Thank you very much, Your Honor.
Thank you, Vinnie, and for the kind words, and to the American Bar Association, the New York State Bar, and the Columbia University Justice Lab for sponsoring this important event. I also want to specifically note the work that Vinnie and his team at Columbia have done on parole, which has galvanized really efforts to reform parole in New York and across the country, and help guide my own and so many others' thinking on these vital issues. Vinnie, also congratulations on your appointment as Commissioner of the New York City Department of Corrections. You certainly are running towards the fire, Vinnie, and we are all rooting for you. There aren't many jobs that are more difficult or more important, and I have every confidence that you, from personal experience, that you will contribute greatly to the cause of justice in our city and state. What a fabulous appointment by the mayor. Many of you have heard me talk frequently about the concept of justice, and more particularly equal justice, and how we make this ideal real and concrete for those who interact with the justice system on a daily basis. As chief judge, it was my job to think about how to achieve justice every day, not only in terms of the individual cases that came before our Court of Appeals, but more broadly in terms of the laws and practices that prevail in the criminal justice arena. Equal justice is at the core not only of our justice system, but also of our society. And far too often, we fail to live up to our hopes and aspirations in seeking to ensure that the scales of Lady Justice are exquisitely and evenly balanced. The challenge is, how can we make justice about fairness and the rights and liberties of individuals, and not about the amount of money in a person's pocket or the color of their skin? In this regard, we are here today to speak about the parole system, and specifically the alarming rate at which people who are on parole, particularly of those in our Black and brown communities and with limited resources, are sent back to jail and prison for parole violations, often for allegations of non-criminal technical violations. As we will discuss, this clearly is an area where we are not living up to the imperative of equal justice in any meaningful way. People who are leaving prison after serving their time face serious, serious challenges. They often have few, if any, resources to rely on. In New York City, half of the people leaving prison go directly to our city's dormitory homeless shelters, a difficult, often chaotic setting that does nothing to support a person's efforts to rebuild his or her life in our communities. Access to stable housing, access to economic opportunity, access to health care. These critical needs are hard to come by. Yet rather than focusing on meeting these needs, we have a set of parole rules that too often become tripwires that send people back to jail and then prison before they can take meaningful steps towards rehabilitation. Jail and prison are immensely expensive, but ironically, they are the only resource that we freely provide. When people on parole are accused of breaking a parole condition, perhaps by missing appointments with a parole officer, or missing curfew, or failing drug tests, or deciding to leave a shelter to stay somewhere else without their parole officer's approval, they are automatically sent to jail while the allegations are litigated in an administrative process. People who are accused of these non-criminal acts have no chance to go before a judge to seek release or even to post bail, unlike people charged with even the most serious criminal offenses. Here in New York City, they spend weeks and often months under traumatic, almost dangerous conditions, often dangerous conditions, back at Rikers. And the racial disparities that we see throughout our justice system are especially pronounced when it comes to parole. For those of us invested in the fairness of New York's criminal justice system, parole reform must be at the top of the list. Yet for decades, parole has been far from a priority for policymakers, the media, and advocacy groups. It has flown under the radar for far, far too long. This is incomprehensible, given the visibility of the problem here and throughout the country. Nationwide, there are 4.4 million people on parole and other forms of community supervision, such as probation, a phenomenon that some have described as mass supervision that parallels and perpetuates the American system of mass incarceration and the warehousing of human beings out of sight and out of mind. Here in New York State, we have 35,000 people on parole on any given day, roughly as many as are in prison. And each year, a staggering 40% of the people admitted to New York State prisons are sent there for parole violations, not new felony convictions. This is truly remarkable and unsettling, to say the least. Why is it that parole has received so little attention? I think the answer is obvious. As a society, we too often ignore those who have been convicted and sent to prison. We prefer not to think about them, to forget about them, ourselves forgetting that nearly everyone who enters prison, even the most serious offenses, will someday come home to our communities, our families. In reality, their ability to reintegrate, to reconnect, to rebuild their lives has a powerful impact, for better or for worse, on families and communities across our city, state, and nation. Thankfully, there is a growing awareness of the importance of parole as a driving force behind the overuse of jail and prison and the victimization of human beings who desperately need a helping hand. Researchers and advocates are finally training their attention on parole. Philanthropic institutions are increasingly putting their money behind reform efforts. And many states have already started to make critical changes intended to limit incarceration for parole violation. Here in New York, we like to think of ourselves as leaders in criminal justice. We do have a lower rate of incarceration than most states, and we have caught up to other states by raising the age. We also have passed bail and discovery reforms that have altered the pretrial landscape and helped put our state at the forefront of national efforts to end cash bail. While those pretrial reforms have proven controversial in some quarters, and I don't agree with them in every aspect, there is no doubt in my mind that they represent a giant leap forward towards justice. And I would note as an aside that there is no evidence or data that suggests that these reforms have been responsible for the challenge of increased shootings that we have seen in New York City and in cities across the country amidst the devastation of the COVID-19 pandemic. Yet when it comes to parole, New York is dead last in the nation. We incarcerate more people for parole rule violations than any other state in the country, with Black people sent to prison for parole violations at 5 times the rate of white people. And the percentage of people who go to prison each year in New York for a parole violation is 3 times the national average. For every person sent on parole who is convicted of a felony, another 5 people are sent to prison for rules violations, and almost 3/4 of the people on parole are returned to prison, the vast majority of whom are locked up for rules violation. All of this is an absolutely massive failure for our state and a flashing red light that people in New York State, that parole in New York State is not operating as it should. Beyond that, putting parolees back in jail has a tremendous impact on people, families, and communities, wiping out any progress that they've made since coming home, setting them back to square one. In addition to these very real human costs, the financial costs are also tremendous. In 2019, New York state and local governments collectively spent more than $680 million to incarcerate people on parole for rules violation. Doesn't make any sense. What's more, there is no evidence whatsoever that this massive expenditure of resources is keeping us safe, which is why parole reform in New York is supported by district attorneys, not only here in New York City, but upstate and in Long Island, as well as by sheriffs, former law enforcement officials, and the state and city bar association. The system as it exists today is counterproductive for all who are involved, and that includes parole officers, who by no means should be blamed for the system's failing. To the contrary, they have a very tough job and they have been set up to fail. They have high caseloads and limited resources. They have little in the way of housing opportunities, options, job opportunities, or educational opportunities to provide to the people that they are supposed to help and supervise. Instead, their only unlimited resource is jail, which in almost all cases is not helpful. And then we turn around and blame them when something goes wrong. Is it any wonder that incarcerating people for technical violations becomes the default. But despite all these challenges, there is cause for hope. There are good reasons to believe that change is afoot. As mentioned, policymakers, advocates, and philanthropists have started to take note of the hidden but outsized role that parole has in driving incarceration in New York and across the country. And states where you least expect it have begun to change their parole systems with promising reforms that we can build on here in New York. Many of these are red states, which generally take more punitive approaches towards criminal justice than we do. Yet, from Alaska to Arizona to Arkansas, South Dakota to South Carolina, even Louisiana, these more conservative states have taken steps to reform parole. The results, incarceration and costs have dropped, and criminal offenses by people on parole either decreased or remained flat, debunking the idea that locking people up for technical violations was needed for public safety. Further, caseloads have dropped so the parole officers can finally focus on these people with the greatest needs. Throughout the country, at least 18 states have established good time credits for people on parole that allow them to shorten their term of supervision through good behavior. 24 states have shifted to a system of graduated sanctions for technical violations, limiting jail terms to more serious and repeated issues. And 16 states have capped the length of time that people can be incarcerated for technical violations, promoting accountability and proportionality. All of this points the way towards a better system here in New York and proves that reform can work. There is no excuse for New York, the Empire State, not to be the leader when it comes to parole, as we are in so many other areas. That brings me to the less is more legislation that has been introduced in Albany. This is our best promise for the future. It builds on the reforms in other states and would do many good things here in New York. The legislation would encourage positive behavior through earned time credits. 30 days of compliance with parole rules would earn 30 days off a parole term. It would stop automatically sending people who were accused of parole violations to jails like Rikers. And it would reduce the types of rules violations and minor offenses that could send people on parole back to jail or prison. Reforms like these would also lower parole officer caseloads so that they can focus on helping people reintegrate in society and surely increase public safety. And they will save money, real money, hundreds of millions of dollars that is currently spent on jail and prison for people on parole. Money that can be redirected towards much more productive uses. And I find it particularly encouraging that parole reform is supported by a wide and unique coalition, not just criminal justice professionals of all stripes, but many community groups from across the state, the Association of Counties, and so many others. There is hope on the horizon. The fact that we are all here focused on these issues is itself a very, very good sign. On that positive note, it's time to hear from the real experts, today's panelists, who have such a depth of experience and knowledge on this very important and pressing set of issues that hold the promise of reform that can contribute so greatly to our ultimate goal, making the ideal of equal justice a reality each and every day here in New York. That's what this is all about. I look forward to working together with them and all of you toward that end. Thank you so much.
Thank you so much for those remarks, Judge Lippman, and for kicking us off in such a wonderful way. I'll invite our first panelist to turn on your cameras so that others can see you. And there we go, as folks join in. I'm going to give just a very brief introduction to our first panel's moderator, Seymour W. James Jr. And in the interest of time and to get us straight into the panel discussion, as Judge Lippman indicated, I'm going to be very brief. And I just want to make sure that we're, there we go, that you can see me. Seymour is I'm just going to list a handful of his many roles and accomplishments in this brief introduction. So Seymour is a partner at the law firm of Barkett, Epstein, Kieran, Aldea, and Laturco, focused on criminal defense and civil rights litigation. He has served in several roles with distinction, including as the former attorney-in-chief of the Legal Aid Society in New York City, and as past president of the New York State Bar Association. Especially relevant for today's discussion, he currently serves as co-chair of the State Bar's Task Force on the Parole System, and Seymour has also served on several important state and city commissions and is the recipient of a number of awards for achievement and extraordinary commitment to the legal profession. He's a graduate of Brown University and Boston University School of Law. Thank you so much for moderating this discussion, Seymour. I'll turn it over to you and just make sure that everyone can see you. I'm just going to bring everyone in. There we go.
I think I've been connected now.
Perfect. Sorry about that, Seymour.
Okay, that's okay. Okay. Well, thank you for that kind introduction, Kendra. You know, before I introduce the other panelists, I just want to tell you a little bit about the Task Force on the Parole System that I was privileged to co-chair at the State Bar, and give you a brief summary of our findings. There really is little or no evidence that the current revocation process for technical parole violations enhances public safety or reduces recidivism. In fact, there's actually a stronger argument that incarcerating people for technical parole violations plays a negative role in integrating people back into the community, and it's extremely costly in human and economic terms. So some of our recommendations were to eliminate the authority to issue warrants for people who are only charged with technical parole violations, and instead give them a notice of violation telling them to appear. If in fact a warrant ultimately has to be issued because they deliberately fail to respond, that they have to be brought before a criminal court within 24 hours for the court to make an assessment as to whether they should be released. And then also to reduce incarceration for the adjudicated technical parole violations, and reincarcerate people only when the alternatives to incarceration have been fully exhausted. And that graduated sanctions should be imposed, starting with community-based drug treatment, mental health or cognitive behavioral treatment programs, and then limit time assessments to no more than 30 days of intermittent, or sometimes intermittent sentences. And then reinvest the cost savings to get the person to a violation of parole, and describe the impact on a person's life when they're jailed for a technical parole violation.
You see more. Can you hear me?
Yes, I can.
Okay, perfect. Thank you, Seymour. And I can start by describing some of the violations. And so as very eloquently stated by the Honorable Judge Littman, he mentioned that failure to attend scheduled parole officer meetings was a frequent cause of parole violations. Late arriving, and by the way, I believe it's important to note that parole officer meetings are often scheduled during daytime, 9 to 5 hours, which often conflict with employment. So that presents challenges for someone who is just coming home, trying to get their life together. There's also late for curfew. And oftentimes these are things that are also beyond our control and are not criminal. So you may be coming home from a long commute home from work, and you may be subjected to incarceration for arriving late. There's also the failure failing a drug test. And so failing a drug test, to me, is indicative of someone who requires therapeutic services, not incarceration. And then lastly, you have traveling without the express permission of a parole officer. Oftentimes, as was the case for me, most of my family is from Jersey. And so I was released to New York. And so I was not allowed to see my family during parole because I couldn't travel without the express permission of a parole officer. In terms of the impact, many people who come home from after serving extensive periods of time have prepared and come home, and they faced a number of challenges dealing with discriminatory practices, with employment, with housing. And despite those challenges, many of them thrive and are able to start to get their life together. And the impact of a technical parole violation, what it does is it disrupts that. It interrupts that. It removes whatever safety net that person may have managed to develop during their time following their release. And it's demoralizing because what it pretty much effectively does is remove and wipes out anything that you may have aspired to accomplish and may have accomplished. It pretty much wipes it clean to the extent that when you are released following a parole violation, you have to start from scratch and start all over. So.
Thank you. Ms. Hilton, the impact of the parole violation really extends beyond the individual who has been placed on parole. Please tell us how the violation of parole affects the person's family and the community at large.
Hi, everyone. Good afternoon. Thank you for that question. So one of the things that we don't readily recognize is that when we continue to send people to prison, we continue to disrupt and to tear apart families. And so we do the same thing to communities. As most of us know, and for those that don't, women have become the fastest growing population being sent to prison for whatever reason. And the vast majority of those women are mothers. And so when you take a mother away, you disrupt the family, you tear it apart, and it just goes downhill basically from there. But also with the men, right? We have many men that are fathers who are also primary caretakers of families. And so the same thing happens. And so what we have failed to understand is that the community at large is impacted by this because these are people within the community that really want to contribute, doing their best to basically acclimate and do good and just become contributing members of their communities. We give back so much. I myself, being an impacted woman who served 27 years, I have now created an organization. And so now I have the responsibility of a full team plus a much larger community than I ever thought possible. And if I was to get violated today, what would happen? What would that mean for the things, the services that we're providing and the people that we're taking care of? We never look at it like that. We have people that we work with and that we're fighting for now who are facing violations who basically did not commit a crime. And so we can't continue to have that because the communities that these people represent are the communities that are the most hid. And we call them $1 million blocks, and they continue to be marginalized and so under supported. And so we must understand that we need to stop parole violations of any kind if they are not anything to do with a new crime.
Thank you. Let me turn to you, District Attorney Gonzalez. Many people argue that people on parole who violate the conditions of their parole should be jailed in the interest of public safety. Do you agree with that premise? And if not, how do you think we should handle the matters of people charged with violations of parole?
Well, let me first start off by saying good afternoon and thanking Donna and Glenn for sharing a little bit about their experiences. I came into this position with the explicit goal of keeping the people of Brooklyn safe and making sure that our justice system actually inspired trust in our criminal legal system, that we were doing things that actually kept people safe, but that there would be fairness. And this sense that, someone who's on parole is worthy of being reincarcerated for a technical violation without having other measures put in place first to deal with the humanity of that person seems wrong-headed. And quite frankly, one of the reasons why our parole system is failing. So I don't agree. I think that we have to try to figure out what the violation is that the person is alleged to have committed, and a technical violation by itself seems to be a disproportionate sanction to send someone back to prison for having committed. And I want to be real clear on this. For all the reasons that we've heard, that, you know, separating someone from their community as they're re-engaging and they're involved in re-entry is the opposite of creating safety. As district attorney, I've taken some unusual steps in my office to limit the impact of parole, which is, you know, my assistant district attorneys are asked to ask for the minimum amount of parole unless they have a good reason to ask for the most. Unfortunately, in our court system, it's not uncommon for judges to always impose the maximum period of post-release supervision, which further helps create this massive infrastructure of supervision, and thereby further making it a reason why often violations are being offered as opposed to getting services and treatment. But I think that as district attorney, it's important for me to tell the community that I do not believe that putting people back in jail for making a mistake and not getting services and connections to them is in fact keeping us safer. It's clear to me that that kind of recycling of people in and out of the criminal justice system and treating those people as inmates and not people who are have already been held accountable and moving on with their lives is destructive to our community, and it further alienates public trust in our justice system for the reasons why Donna and Glenn said, because attached to that person is a family and a community that wants to see them succeed.
Thank you. You know, I think I'd like to point out that, you know, I think your view is shared by a number of prosecutors throughout the state, and I know some of them have signed on to support the less is more bill, which I understand I believe you were one of the first people to do that. So
I believe I was the first district attorney
the very first.
to sign on onto this. I'm a true believer that the less is more bill will keep our community safe and restore fairness into our legal system. You know, among all of the reasons that we've just mentioned, you know, it's also shocking the lack of due process people are given as they're being put through this parole apparatus. And so for a lot of reasons, and, you know, Judge Lippman really covered it very thoroughly, we should all be supportive of less is more.
Okay. So you talk about the due process. That's a good segue. So, Ms. McEvely, what happens when a person is arrested and given a desk appearance ticket to appear in court on a future date? And if a person is charged with a new criminal offense and detained on a parole violation based on that offense and subsequently released on that offense, will they continue to be held on that parole violation?
Yes, thank you. A lot of times what we see in our practice as the providers of legal representation in New York City for accused parole violators, what we see is many times a desk appearance ticket or an arrest by NYPD with a desk appearance ticket attached to it more often than not results in a warrant being issued at either the precinct level, requiring the person to go to Rikers, or derails the desk appearance ticket from being given out and causes the person to be, the issuance of the warrant causes the person who normally would just be given a desk appearance ticket to be taken to the criminal court arraignment because of the parole warrant. So what happens is, and if they are given a desk appearance ticket and they go to report to parole, many times they are arrested despite given a desk appearance ticket and are arrested on a parole warrant and then brought to Rikers Island, where they are remanded and will be held depending on if they ask for a preliminary hearing, they'll be held for a minimum of 15 days. If the parole officer is able to have the person get the person to waive their preliminary hearing, then they'll be held for a much longer period to await the first of the final hearings. So more often than not, a desk appearance ticket, in our practice at least, has resulted in a remand situation on a parole violation. It completely derails the intent of the desk appearance ticket and leads the person into an incarcerated setting. And as far as if they're released on a new criminal case or the case is dismissed, what we see is that the parole violation usually lives on. There's no law requiring a parole docs as an agency, who's the prosecuting agency, to dismiss any charges related to a new criminal case that has been dismissed or ACD'd or resolved with a violation. The law allows them to continue in the parole violation process. There's a different standard of proof, a much lower standard of proof, a civil burden, and the remand continues. And it's basically a system where once you're in on the remand for the parole violation, you really just have to kind of scratch and claw your way out of that remand, if that's at all possible.
So I heard you mentioned people who were cases are dismissed or is a violation or German contemplation dismissal. Does that also apply to a person who's actually gone to trial and been acquitted with parole?
We have seen situations where parole holds, I've actually personally represented clients who have received acquittals in criminal court, but are still held on the parole violation. They're still have under remand. The judge in the criminal case where there's been an acquittal has no authority to lift the parole hold. And the parole hold exists separately in the track of the DOC's administrative hearing process. And so people, if the day that you get a not guilty verdict, even if your parole warrant is based on largely on those criminal charges, you still have to be kept in remand and brought to the parole violation system to try to fight for your freedom.
And if I could add to that just briefly, Seymour, during the pandemic, we were trying to reduce the population of folks who were being held inside. And there were a number of cases that came through my office during this period of time where a person had been on parole and we were not prosecuting those cases. We were declining prosecution of many of low-level offenses of the lowest level during the pandemic. And even though my office was declining to prosecute the cases, the folks were being held on these parole violations. And so that was particularly troubling during that period of time because they were being held for weeks and months at a time.
I think that's one of the things that the Less is More bill would address. So hopefully we can see some progress in that regard. Thank you, Ms. Diaz-Gonzalez. Mr. Rodriguez, are there any incentives given to persons on parole for satisfactorily completing their periods of parole? And what role would incentives play in helping a person comply with the conditions of parole?
Thank you for the question, Seymour. The current system as it exists, there are no short-term incentives. The only existing incentive at the moment is there's a discretionary review after a 3-year period of being on post-release supervision, upon which your case is assessed, and depending on your adjustment, you may be potentially discharged early from parole. But that is not a mandatory thing. It doesn't just happen. So there are no short-term incentives. Incentives, which I believe Less is More bill proposes earn time credits for every 30 days that you do on positive adjustment. For every 30 days of positive adjustment, you earn 30 days back. That would definitely support people through their transition and motivate them to want to, push forward despite the challenges that are presented with reintegration. So there are a number of challenges, but this would definitely be a driving force rather than be looking forward to 3 years from now at something that may not necessarily happen.
Okay, thank you. Ms. Hilton, Diaz-Gonzalez earlier talked a little bit about the need for due process in the proceedings. When a person is charged with a parole violation, they're entitled to a preliminary hearing to determine whether there is probable cause for that violation. As we heard Mr. McEvely say, sometimes the parole officer will tell the person on parole to waive that hearing. Is that a problem?
Yeah, good question. Thank you for that, Timur. It is it's a problem. It's very problematic. And I say that because personally, here at the Youth of Light, we've dealt with certain situations like that and continue to deal with situations like that. We've had our participants, the people that we serve in the community, a couple who have been under alleged technical violations, went to report because they had a alleged absconding violation that they had to address. The person was hiding in plain sight. So the person went to parole. This one particular person went to report, and once at parole, cuffs were placed on them, and they were placed into the car, and they were being taken to the county jail from which their incident events happened. So when they were in the car on the way to the jail, the parole officer was telling the person to waive their preliminary, to waive their hearing, like really pushing it, not just talking to them, but coercively saying to push them to waive their hearing. If that person would have done that, that person would have waived their right to a fair, like everyone else, a fair trial, right? Just to be heard. And so what wound up happening is that person was not found guilty or accused of any kind of violation because the person had not absconded. And so it was tricky, right? But I'm using the most difficult technical violations that some people face. Absconding happens to be one. That to show what parole officers, not all of them, because not all of them do that, but we do have some that do that. And so you push people into these situations where, okay, I'm not going to go through this. I don't want to, maybe you'll be nice to me and you won't give me 2 years upstate because I did this. Maybe you just recommend a year or 6 months or 3 months. And so I won't have to do all this time so I can please the parole officer. So this won't happen. And this is wrong. And we see this happening over and over and over again. Again, it's not every parole officer, but it's enough to be of concern. It is too much. One is too much because then we force people into giving up their rights, giving up the opportunity to fight, which they don't have a fair fight anyway when the process is right now. And so that's why less is more is so important to pass. And so we continue to see this, and we can't continue to have this happen because it's just not morally or integrally right on its face.
One of the provisions of the less is more bill would prohibit the waiver of that preliminary hearing. Ms. McEvely, at that preliminary hearing, individuals are not entitled to representation by an attorney under the current law. However, in New York City, attorneys are appointed for the individual at the preliminary hearing. Would you tell us what effect legal representation at that preliminary hearing has on the parole violation case?
I think it has a tremendous effect. Having a lawyer at the preliminary hearing really sort of stops the momentum on the part of the agencies to just sort of treat the preliminary hearing as a sort of like, I just have to show the paperwork and I am able to substantiate the charges. A lawyer brings to the proceeding a little bit, more gravitas to it, to remind the hearing officer of the standards of evidence, to remind the preliminary hearing officer about the due process rights of the client to participate and to confront and cross-examine. And in New York City, at least, in 2019 to 2020, about 20% of the 2,300 preliminary hearings that were held in that year, about 20% of those warrants were dismissed at the probable cause level. And I attribute, well, some of those might have been administratively dismissed because the state just wasn't ready. I do believe that having the lawyers representing the clients and really challenging the evidence makes a huge difference in the outcome. In addition, asking for a preliminary hearing and insisting on a preliminary hearing is the quickest way under the current laws to get to court after you've been remanded, because there is no right to see a judge under the current New York State law to see a judge until your preliminary hearing. And that's guaranteed within 15 days, which is a very long time. But if you waive it, it could take up to 90 days before you could see an administrative law judge to try to fight for your freedom. So having lawyers at the preliminary hearing is really important.
And that's another provision that less is more would address, mandating the legal representation at that preliminary hearing and throughout the parole proceeding. If a person is unable to afford an attorney, that one would be provided to them. District Attorney Gonzalez, how can parole make better use of alternatives to incarceration for those charged with violations of their parole conditions?
Well, it should come with an understanding that what the parole system was really meant to do was to help people succeed and transition back into their community. And if a person is struggling, maybe late appearances with a parole officer, maybe misses an appearance, it should be indicative of the fact that a person may need some support, may need services, and they need some help. And we should think about our folks who are currently on parole the way we think about people who are pending in our criminal justice system, thinking that we can have safety if we can work towards making them successful and maybe changing some behaviors. And, we should really be demanding of our parole system that incarceration, a re-incarceration, is considered a failure, that the person and the supervision of the person has been unsuccessful and a failure and a last resort. So making sure that we connect persons to services, we connect them to people in the community that can help them be successful and model appropriate behaviors is important. But at no time should our, parole system be sort of a mechanism that's meant to trip people up for having some failures in their life and then reincarcerate them. Very few people are perfect, and many people coming home from jail or prison, as we know this, are dealing with all kinds of issues, trauma issues and other kind of issues. And these are appropriately handled by community-based organizations and other people in our community to make sure they're successful. If they are successful, then our communities will be safer. And again, I believe that's the appropriate way to handle these issues, especially very few people are being rearrested on violent new crimes and are actually posing a public safety threat. And so to use this money and to use these resources is really not being done in a smart way. It's creating this large system that's not actually focusing its resources on the people most deserving of intensive supervision.
Can you elaborate a little bit on some of the programs that you run in your office for people who are charged with offenses, those alternatives to incarceration that have successfully enabled them to navigate the system and to, get themselves back on track?
Yeah, so one of the most important changes that I made to the way we handle cases is by having non-law enforcement personnel making an initial assessment. So we in my office use social workers and other trained staff to make assessments, working with defense attorneys on what the needs of the person who are in the criminal justice system are, to figure out if we can find preventative solutions to why they've entered the legal system in the first place. It's about accountability, of course, but in the long run, it's about making sure that the person doesn't reoffend and doesn't hurt anyone else, or is not committing more crime. And so in my office, we're running a bunch of different programs that really are meant to get to cognitive behavioral changes by using people in our community to help support and help run programs. So a lot of that looks like peer counselors. A lot of that looks like people who are similarly situated and have lived life experiences and are going to make a difference. We do incarcerate people in the DA's office, but it's at a last resort. And we're running a lot of different programs that are based on harm reduction models. And I've seen tremendous growth in these people, and I've seen really good stats for what it's worth for people who are concerned about this in terms of saving money, but also reducing reoffending rates.
Thank you. Ms. McEverly, currently parole revocation proceedings are conducted in correctional facilities. Does that practice present a problem for persons who are charged with these violations of parole?
Thank you. It really does. Having the hearings in a correctional facility is, first of all, it provides a huge access issue on so many levels. It's inaccessible to the public at large. It's inaccessible to the press. It is probably most importantly inaccessible for the families of people who are under remand in parole violation warrants and families that want to see their what's happening to their loved one in the parole proceeding. They want to see what evidence, how their loved one is being treated in the process. Having it, first and foremost, having it in a correctional facility basically takes the whole process and hides it into a secret room, and almost like a star chamber where you just cannot, there's just no access there. The second piece of it is the person, the person who's accused, it's hard to create any kind of sense that this process is going to be fair, that it's going to be open. The person is already coming to the process in the garb of being incarcerated and is being treated as an incarcerated person in a jail where they are being, in the very same jail system that they are being held in. And the third logistical problem is that every room in a correctional facility that I've been to for a parole violation hearing has been tiny and incredibly cramped and completely inappropriate for a decision being made about somebody's liberty. And so people can barely fit in the rooms to hold hearings. Witnesses are cramped up, on top of everyone else. And it doesn't feel like a judicial proceeding. It doesn't feel like a tribunal. And it gives the impression that the liberty interests of the person who's accused is really on the level of like what would be an inmate infraction hearing. Again, going back to the comment made earlier by one of the panelists that the whole process is sort of treating the person as an inmate rather than as a civilian, a citizen with liberty interests.
And and how long does the parole board? I think you mentioned that it's 15 days to a preliminary hearing, and then I guess 90 days to the final hearing.
Correct.
How long do these proceedings generally take? And we heard Mr. Rodriguez talk earlier about the fact that how it disrupts the person's reentry and makes it almost necessary for them to start all over. How long does it take to actually complete these hearings? And
on the average, it takes, whether you have a preliminary hearing or you waive the preliminary hearing, nothing really happens quickly. If you waive your preliminary hearing, I noticed somebody commented in the chat, well, if you waive, you'll get to court quicker. That is simply not the case. Even if you waive your preliminary hearing, because of the bureaucratic delays and the inability of the DOC's parole violations unit to schedule things quickly, most people wait up to a month for their first final hearing, whether they've had a preliminary hearing or they've not had a preliminary hearing. They are 30 days in at the least when they come for their arraignment. Sometimes they are brought a little sooner than that, but in most instances, they are somewhere between 2 and 4 weeks before sitting in jail, before they're even brought to their first hearing where they get to see a judge and the evidence against them. So what ends up happening as a whole is, even if our clients are returned back to the community in the parole violation process, they have usually spent on average 60 days or more in jail waiting for that decision to be reached and to be released back into the community. And there are other individuals who wait a lot longer before they're ultimately returned. A decision is made by an ALJ that instead to send a person to prison for the violation, to return them back to the community. So people who are already determined to come back are kept in for 60 days or more, waiting for that to happen. By the time they get out, they have lost their stabilizers. They have lost their employment in most cases. They have disrupted treatment that they've had in the community that they were participating in, and they have lost their homes because a missed rent payment is sometimes enough to lose your room in a house, to lose any temporary housing that you may have had. And it's a complete disruption. And more often than not, docs will oftentimes just send people to shelters. If they don't have an approved residence, if they've lost their residence while they've been incarcerated, they will be returned to a shelter system and not even have the housing that they had. And we know housing is extremely important for reentry.
Thank you. So I think we're running out of time. So I have one last question. I'm going to open it up to the entire panel. So the periods for incarceration for violating parole can range up to, further incarceration up to the maximum expiration date. Should these periods of incarceration be reduced? Leave that, open that to anyone who would like to respond.
I'd like to jump in real quick on that question, Seymour. So for me, being a person that is directly impacted and how parole has affected, and understanding the work that I do and helping the people that I help, I think that, and to our points that we are all making here, that people have not committed a crime, right? A violation on its face is just not a crime. So to want to send someone back to prison for not committing a crime, but to, a misstep, a mistake, or an infraction that no one who's not a part of the criminal legal system would be sent to prison for, to give that person time in prison instead of giving them the resources and the help and the opportunity that they need to get themselves together, should be the first thing. It should not be another sentence. We continue to respond to things with incarceration. We penalize and we criminalize every single thing. And parole on its face was not created to do that, but we know it has turned into that, where it is now another weapon used against people, that if you don't do this, if you do that, everyone's always like this, we're always like this, like walking on eggshells. And it's so difficult. It's so difficult to walk this walk. We're talking about, a lot of the people we're talking about spend decades in prison. I myself served almost 3 decades. So to force me, to rush me into getting this right, do this. I mean, every little thing, if I make a misstep, then you want to send me back to prison for 2 years or a year? Where's the sense? And so we're talking about communities. This is not a way to help communities or to support communities. We are better served and we morally correct if we help people. If we invest in the communities, invest in the people. We continue to criminalize drug abuse. And it's not drug abuse, it's dependency. And why do people have dependencies? Because there's something wrong, but we don't look at that. We criminalize poverty. We're locking people up for being poor and trying to survive. Not saying what they're doing is correct, but if they're not committing a crime, then they should not be going back to prison.
One of the things that
Right.
less is more will do, just to specifically to your question, Seymour, would be to cap the amount of jail time someone could face on these technical violations. I think it's to the extent that they're allowed to reincarcerate someone would limit on technical violations to 30 days, I believe. So I think that's another important reason that less is more is very critical. And quite frankly, to Donna's point, I have a reentry bureau in my office, and I would love a parole officer, to actually refer someone to the reentry bureau as opposed to, even yo-yoing them into 15, 20, 30 days in jail. I think would be a better use of our taxpayer dollars.
Thank you, Eric. So I want to thank all our panelists. I think you've been really enlightening for our audience. And I appreciate the time that you spent with us this afternoon. I'm going to turn it back over to Kendra because I think it's time for the second panel.
Thank you so much. And just echoing Seymour's thanks, and Seymour, thank you for leading us through that discussion. We're going to dive right into the second panel. So I invite all of our first panelists to turn off your cameras and all of our second panelists to turn on your cameras. And as that's happening, I'm just going to give a brief introduction to our second panel's moderator, Wayne S. McKenzie. And as before, in the interest of time, I'm going to focus on just a couple of the many highlights in Wayne's bio so that we can jump right back in. So Wayne serves as general counsel for the New York City Department of Probation, where he is the primary advisor to the commissioner and fellow cabinet members on all legal, legislative, and compliance matters. Prior to joining the Department of Probation, Wayne was the founding director of the Prosecution and Racial Justice Program at the Vera Institute of Justice, and before that, a prosecutor in the Kings County District Attorney's Office in Brooklyn. Wayne sits on the American Bar Association Criminal Justice Section Council, where he is currently chair-elect, and that section is one of the co-sponsors of today's event. And Wayne is also a past president of the National Black Prosecutors Association and a two-time recipient of the association's Presidential Award of Excellence, among several other awards. He is a graduate of the City College of New York and the George Washington University School of Law. Thank you so much for moderating this discussion, Wayne, and I'll turn it over to you.
Great, thank you for that kind introduction, Kendra, and thank you to the Justice Lab and the New York State Bar Task Force on the parole system. And in keeping with the brevity and time, I too am going to jump right into introducing this fine panel, and my introductions will be very brief, after which each panel list will give you a 2-minute opening statement, so to speak. So first we have Denise O'Donnell. Ms. O'Donnell is a strong advocate for parole reform and is chair of the revocation subcommittee of the New York State Bar Association's task force on the parole system. So Denise, if you can jump on in here with your opening comments.
Great, thank you for having me. I have approached this issue of parole reform improvements and essentially reducing the number of parole revocations from a number of different vantage points. I was director of the Bureau of Justice Assistance and worked on the Justice Reinvestment Initiative that I'll talk a little more about. I was, before that, the director of public safety in New York under 2 New York state governors who, had some responsibility for parole and worked with the Vera Institute on some parole efforts in New York early on, and then was a career prosecutor and U.S. attorney, and now serve on the commission or the task force. And, I have to say one common theme that has gone through all of the presentations has been how parole is really the black box of the criminal justice system. For so many years, I did not understand it, even as a prosecutor, even as a career prosecutor, and understand the harmful impacts that parole can really have on people returning to the community. And I think a lot of judges and lawyers were similarly situated. And now to look at the exorbitant costs and the human costs of the parole system, and the fact that it's not really protecting us as New Yorkers, is a call to action that we really need the less is more bill. So we are on this panel really talking about opportunities. We've talked a lot about the system and what's broken, and there's a lot of opportunities out there. So at BJA, I was lucky to work on the Justice Reinvestment Initiative with Pew and the Council of State Governments, and to see that almost half of our states have implemented parole reforms. And one of the biggest reform is incentivizing positive behavior. We've heard so much of the parole system is negative, and to give people incentives, to give them control over reducing their time on parole, 30 days for good behavior, incentivizing them to follow the rules, is an extraordinary opportunity for us in New York, and can really not only reduce the amount of time people spend on parole and the number of people on parole, but can really help induce positive behavior for people on parole. So there were so many other things that the prior panel talked really passionately about the system itself and the lack of due process in the system. And I think many people are surprised that a parole officer can violate someone immediately and put that person in prison, in jail. And that the amount of time people can stay there, the disruptive impact is just overwhelming. And so the Less is More Act now has put in some provisions to really be able to control how a parole violation can actually take place, whether someone has to go immediately to prison or can have a due process hearing within a court to be able to resolve that. Using graduated sanctions is so important, and it's so missing from the current process. So to really make that the way to proceed in kind of parole violations in situations to allow prison only as a last resort for serious violations is a really important part of the Less is More bill. Capping the amount of time is crucial when we see how much time people can get under our current system for what are not criminal violations. So that's important. Alternatives to incarceration, it's so important. We have so many people going back to prison, being violated for failed drug tests, who have substance use disorders, and our treatment resources are really in the community. So that is critically important. So I think what's significant is the number of states that have been able to do these same reforms and been able to achieve lower recidivism, much better outcomes for people who are on parole, and the fact that we can then reduce the size of parole caseloads. So parole officers can do what all of us expect that they are doing right now, which is assisting people as they reintegrate to the community. So there's lots of opportunities here, and I'm just so hopeful that we will not forego this possibility of enacting what are really critical reforms to New York's parole system.
Okay, great. Thank you, Denise. And Denise jumped the gun by even going deeper into her presentation. So we're going to hear more from her, but I'm going to remind our other panelists just a 2-minute opening comment, and then we'll start unpacking more about potential reforms. So next we have Julie Kemper, who's currently the Missouri Director of the Division of Probation and Parole. Julie?
Good afternoon. Thank you very much for inviting me today to present on the Missouri experience. I feel really far away from you all, being in the Show Me state of Missouri. I am the Director of Probation and Parole, and was also the reentry manager for many years within the Department of Corrections. And so I really enjoyed hearing you all talk about reentry and the importance of preparing people to come home, and more importantly, to stay home. I joined to listen to the first panel, and it's always very encouraging to know that all of us struggle with the same kind of issues, regardless of where we're located, and that it's not just happening in the state of Missouri. This job is hard, and it's oftentimes hard for everyone in the criminal justice system to agree upon one single definition, and that is defining when someone is truly a threat to public safety. And I truly believe that that in itself is part of the problem. I'm anxious to share with you some strategies that we have implemented in Missouri to reduce the number of returns to prison as a result of technical violations received while on probation and parole supervision. I will tell you though, before I get started, regardless of what strategies Less is More has incorporated within it, and regardless of what strategies we try to incorporate to master this, the change in community supervision practices starts with changing the culture of your organization, especially when you're moving from one that appears to be a punitive culture to one that recognizes the evidence-based practice of actually incentivizing behavior. This requires leadership that genuinely supports and believes in the strategy and is equipped with the support to educate your staff and educate the way we philosophically think about community supervision. So while I have some strategies to share, I had to share first and foremost how important it is that it starts with the leadership of your community corrections organization. So again, I look forward to sharing some of the specific strategies with you shortly. Thank you.
Next, we have Dr. Amanda Seward, who's currently a professor and the director of criminal justice at the City University of New York, Kingsborough Community College. Dr. Seward.
So good afternoon all, and thank you for allowing me to join you this afternoon. So I feel like I've been around the block a couple of times because I came into the department back in the 80s. I was the first substance abuse counsel for New York State Department of Corrections. Left, came back as the statewide director for reentry services, appointed by then Governor Patterson. I also worked for the Brooklyn District Attorney's Office as the executive director for ComAlert, the first full service reentry program in the country. Left, came back, and then was working for a division of criminal justice services under the reentry task force umbrella. And now at the City University. And I just want to say that I think that having the opportunity to really look at the landscape and really understand the issues on all different levels. I think one of the things when I think about less is more, and I listened to the first panel, is that if we can just get everybody just to listen to and look at the data, if people can just look at the data and let the data lead us, we would be so much further along when we talk about criminal justice reform. I think we sit at these tables with all the right people, say all the right things, and then when the data comes out and it's time for us to move the needle forward, it's almost like somebody pulls out the emergency brake and everything comes to a halt. And I think we've had so many less is more conversations. And I think the people understand. I really believe that everybody that we talk to really understands what it is that needs to be done. I think that the people who don't understand and have the most apprehensiveness are the people who actually are doing the work. And I think that it's not that they don't want to do this. I think that it's new. I could remember when I worked with Denise O'Donnell when we talked about reentry and compass and phases, and we used what we wanted to call at that time, I called at that time almost like the dirty word, which was reentry. It was like a showstopper. back then. As soon as you said reentry, you can hear a pin drop in the room. So I think we have to really take this time and really talk to the people who are out there doing the work, who's trying to enhance public safety, and get them to understand that we appreciate what they're doing. And I don't think their practices are no longer outdated. I really don't. I think the mindset, the sense of security as an individual, the sense of what is it that the public is looking for really is what the issues are. So I think as we move further on with this conversation, we will hear from all different people from all different perspectives, but I think that we're kind of narrowing down, who really needs to hear this conversation, because it's not the people sometimes who are tuning in. It's almost like we're talking to the choir sometimes. We have to get, as my colleague, Dr. Pryor used to always say, we seem to talk to the regular people. We need to get to the unusual suspects. And the unusual suspects right now are the people who are doing this work, who we have to get them to realize we're on their side. We understand, but we want them to understand where we're coming from and get them to understand what the data is reflecting. Thank you.
Thank you. And talking about the people who are doing the work and the unusual suspects, and who I'll call the thorn amongst the roses on this panel, Stanley Richards, the Executive Vice President of the Fortune Society, which is a service and advocacy nonprofit organization in New York City. Stan?
Thank you, Wayne, and good afternoon, everybody. I come to this work by my lived experiences, being formerly incarcerated, cycling in and out of jails and prisons, and in my last incarceration, really found education to be my way out of what I thought was going to be my life's destiny. And it really provided a new way of looking at who I am as an African-American man born and raised in Soundview in the Bronx, and thought that my life would be destined to mass incarceration, cycling in and out of jail and prison. And what we find right now, and it was stated in Judge Lippman's opening remarks, is that as a society, we need to generate the political will to do what's right. We know what's wrong with the system. We know that the system that we currently have as parole is defined is not a system that makes communities safer. It is not a system that helps people rebuild their life post-incarceration. And this isn't a mark on the people working in the system. It is the system itself that must be fundamentally changed. And what Less is More does is offer us an opportunity to reframe our thinking around parole and to right-size the investments that we have been spending for decades to damage Black and brown communities and communities most impacted by mass incarceration. Judge Lippman said we spend $680 million on technical violations. Just imagine if we took a fraction of that or half of that and said, you know what, we're going to reinvest it in services so that when people come home, they have adequate housing, they have access to employment opportunities, they have access to mental health and substance abuse treatment, that the only option for parole is violations is removed, and the option to get people connected to services. We could have a much different system. So I'm glad we're having this conversation, but this conversation needs to end with our political leaders hearing loud and clear, the time for change is now. We can no longer afford to continue down a path that disproportionately impacts Black and brown people, Black and brown communities, and disenfranchises so many people in mass incarceration.
Okay, great. Thank you, Stan. Now, Julie, during your opening comments, you were especially focused on culture and leadership. Now, you've spent more than 3 decades doing this work in Missouri, and Missouri has actually already made some of the changes that are proposed in the State Bar Association Task Force and the Less is More legislation. Can you talk about what those changes were and what outcomes you've seen in your own jurisdictions? And even what are some of the key challenges that you had to overcome, especially when you talk about leadership and culture?
Sure, thank you very much. Just to give you some history, in 1990, our prison population was right around 14,000. 12 years later, our prison population was over 33,000. And 43% of those prison admissions were as a result of technical violations while on probation or parole supervision. As you can imagine, as the result of that data, we engaged in our first Justice Reinvestment Initiative. In 2012, legislation was passed that created an earned compliance credit policy that automatically awards credits to eligible individuals who have complied with their supervision conditions. In Missouri, compliance means the absence of a violation report that is submitted by a probation and parole officer during a calendar month. So it's very similar to what I saw in Less and More, basically 30 days off for 30 days of compliance. The officer, the probation and parole officer, then monitors the expected discharge date in our computer system and gives the court or the parole board 60 days notice of the potential discharge. What we've seen is that this policy has allowed clients to shorten their time on probation or parole supervision by 30 days for every full calendar month that they are in compliance. In addition, as a result of the earned compliance credit, supervision periods were reduced. It allowed for caseload numbers to be reduced considerably, which ultimately allowed then our officers to focus on high-risk clients, but they also focused on the first year of supervision when the risk of violations is high. We were able to keep the existing probation and parole officers, the number of them, at 70,000 at one point, down today to right around 58,000 clients on supervision. We didn't lose any FTE. And the reason behind that was at our maximum number of clients prior to ECC, our staff's caseloads were outrageous. And it was very, very unrealistic to get them to do the work that we needed them to do with over 120, sometimes 140 clients on their caseload. We did have certain offenses that were excluded from receiving earned compliance credit. Most were primarily low-level felonies, which were in Missouri, drug and nonviolent offenses. Two of the prerequisites for earned compliance credit was that they had to be on supervision for at least 2 years and that all restitution be paid. And as I said earlier, in 2012, at the time that the earned compliance credit legislation was enacted, we had 77,300 clients on supervision. Today, we have 58,000 clients on supervision. When we look today at the results of the earned compliance credit legislation, you will see that clients are not returning to prison with new felonies at a high rate. We believe that we are granting earned compliance credit, granting an early discharge to those who truly are going to succeed. And oftentimes with the low risk clients, they're going to succeed with or without us in probation and parole. What we're seeing today is our recidivism rate 1 year after release, less than 3% returned. 2 years after release, the recidivism rate is right at 5%. And after 3 years, the recidivism rate reached approximately 9%. So in Missouri, we're believing that the people who are receiving this earned compliance credit and an early discharge are truly today the right people that should be receiving it. Some of the challenges that we faced during implementation was we did not have a computer system that was equipped to do the math. And what I mean by that is it became very difficult for staff to do the 30 days on for 30 days off for 30 days on, and to ensure accuracy. I will admit we also had stakeholders, including judges and prosecutors, that were not really crazy about reducing a term of supervision. And so oftentimes we would be reducing up to half of someone who was given a 5-year term of supervision. And if they played their cards right and did exactly what was asked of them while on supervision, their term of supervision would be reduced in half. And so you can imagine the frustration from some of our stakeholders that reducing a term of supervision that was given because they expected them to do that long of a term. But this is where the education became incredibly important at all levels. And as stated earlier, we had to use the data. We had to use the data as well as the knowledge of evidence-based practices to engage our stakeholders. Today, almost 10 years later, we are still continuing to educate stakeholders on why this practice works. Along with earned compliance credit legislation, just very quickly, we established using citations in lieu of violations for certain low-level violations. And what I mean by that is it would be in comparison to a warning ticket versus going straight to writing a violation report. Because as I said about earned compliance credit, it was absent a violation report is what got them the 30 days credit. And so, as it's been said earlier, when we have special conditions that sometimes are unrealistic, the number of special conditions can be unrealistic. It was really hard to go violation-free for a long period of time when the number of special conditions and the actual special conditions in Missouri are very outdated. So being able to give them a ticket, if you will, which we call a notice of citation, a warning. We also created a behavioral matrix that our staff use today to guide them to ensure that an evidence-based sanction and incentive is given for specific positive behavior as well as negative behavior. It was also mentioned earlier about absconding, and that is the #1 technical violation today for technical violation revocations in Missouri. We changed our policy to allow for a 90-day re-engagement period before a violation is written. And what that means is this allows 90 days for the officer to work towards locating the client, talking with family, going to their employment, and truly trying to re-engage them on supervision before declaring them an absconder. We've also used the data to identify technical violation revocation clusters, if you will, in Missouri. We look at specific geographic areas of the state where a high number of revocations for technical violations is occurring. This is through a project with the Council of State Governments and an organization called Rikers, which allows us to use the data to go down all the way to a probation and parole officer level to determine who is recommending revocation on these low-level technical violations and where is it occurring, so that we as administrators can really hone in to that specific geographic area. And it may require education. It also may require telling staff that if you're in this job to put people in prison, this probably today is not the job for you. So again, the most important piece of these strategies is educating staff and stakeholders about evidence-based practices. It also takes, when I talk about leadership, it takes a philosophical approach that people can change their behavior. and to recognize too that these are Missouri citizens. In Missouri, I continue to remind our staff that we save our prison beds for people that we are truly scared of, not the people that we are mad at. And so when you think about that, it really is looking at the cost of prison beds for people that are genuinely a threat to public safety and genuinely people that we're scared of having in our communities, not those particular clients that might wreak havoc in the community and those that we're mad at and sick of supervising and sick of coming in and out of prison. We're really looking at saving those prison beds for those people that we're scared of, not those that we're necessarily frustrated or mad with. So I'll turn it back over to you. That I can talk about this for hundreds of hours, but we have some great panelists and I'm certainly willing to help after our panel discussion with any of the specific strategies that we've implemented.
That's great. Thank you, Julie. And it was pretty refreshing to hear you even validate Vonda's emphasis on the data, right? Absolutely. If you can't count it, you can't measure it. If you can't measure it, you can't manage it.
Exactly.
And before inviting Denise to sort of comment and expand on some of the things that you said in terms of what it looks like in New York, you kept repeating one word, and I want to follow up with you. And that was client. You didn't say defendant. You didn't say parolee. You didn't say offender, right? And you talked about culture change. Using the word client, was that something that was intentional? And if so, why?
Well, to be honest with you, we're in probation and parole in Missouri. We're moving away from client because that even still, from offender to inmate to defendant, in Missouri, we're repurposing, and today it's about justice involved individuals. So client, we've gone through several phases over the last 33 years I've been doing this work. But today it's about people involved in the justice system. And I'll take it even one step further. I don't even like that. In Missouri, to me, they are Missouri citizens, period.
Okay, thank you, because as we all know, labels matter.
Exactly.
So, Denise, in light of some of the reforms Julie was discussing and with all of your work, right, what does this system of reforms sort of look like here in New York? I think you're still on mute. Denise?
Okay, you're saying currently, what does it look like? So currently we don't have.
What would these reform efforts look like or should look like in New York State?
Once we've implemented them. So great. And that's a good, I want to follow up too on a question that was put up for us, which is, why do people have to get 30 days of incarceration for a technical violation? I was like, no. Under less is more. They certainly don't need to get 30 days. 30 days would be the maximum that people would get. It would cap at 30 days if people need to be returned to prison. So the whole thrust of less is more, and I think what all of us are saying today is that we don't think most people need to be returned to prison for any kind of a technical violation. We think that for them to really get the support they need to be in the community. And we need to have more programs, but we already have programs that can really assist people. So, we talk a lot about the fact that many people are in prison because of using illegal drugs and having a substance use disorder. And we've come to the realization, I hope, in the criminal justice system, that this is an illness, it's a disease, that we need to treat it. And we have treatment. We have medically assisted treatment. We have treatment programs in the community that can assist people. Why then are we sending people back to prison because they have a substance use disorder and fail a drug test? You know, that needs to end. And the Less is More Act provides a way for people to get those kinds of services in the community and not going back to prison because of it. The part about changing the culture, I think, that Julie mentioned is so important, because our culture now is punitive. And it is, I think Judge Lippman spoke of tripwires in the system, but it's very hard to comply with all of the conditions. And there's no evidence that because people can't comply with those conditions, that they're going to commit another crime. So we really need to be able to help people return to the community and transition in the community. And by reducing the caseloads that parole officers have in New York, which are exorbitant, as much as the paperwork and everything else that they do, so that they can concentrate on the people that they need to concentrate on and not on others, by shortening terms of incarceration, we can really refocus the resources that parole has. They can do the job of helping people, support people as they transition to the community. Again, you know, why do we have so many people coming back without IDs? Why do we have so many people coming back without have immediate access to housing and other types of support, motivational interviewing, other kinds of programs that are out there that the evidence shows works, that our probation officers can be spending their time with instead of the punitive system that we currently have. Now you're on mute.
Thanks for returning the favor. Avonda, you've been in the trenches in this reentry and parole space here in New York City and New York State. You know the culture, the competencies, the capabilities landscape. Is there a system capacity for reform? And equally important, is there an appetite for reform? And what's the balance in terms of solutions that exist or can exist within the confines of parole versus solutions that parole will always impede, right? Unless they're scaled back. I mean, how do you strike a good balance in policy reform? I know that's a mouthful, but I know you can.
Well, I think there's two things. I think the first thing is, if we look at the makeup of a parole officers have 4-year degrees, and it wasn't until 2014 that they allowed individuals that had 4-year degrees in any particular field. Prior to that, you had to have a 4-year degree in psychology, social work, sociology, some sort of human service field. So if we understand that the parole officers are coming with degrees in the human service arena, I'm going to say that they have the capacity to think from a human service perspective, because in addition to having the degree, you had to have some experience to go with that. So it wasn't like you just had the degree and then you were grandfathered in with nothing else. I also think that going back to the days when I said we had to use that word that no one liked, reentry, you had individuals who were very resistant to that reentry, who thought that, using my old, boss, Charles Hines, thought that we was doing that hug a thug thing, that we was massaging the thugs, but that wasn't what this was about. And they thought we were being soft on crime, and that wasn't what this was about either. What it was about was meeting individuals where they were at and being able to do graduated responses. And graduated responses is so much different from graduated sanctions, because as someone did something good, you were able to give them something good. If somebody did something that needed to be addressed because they didn't quite get it right, you were able to give them the right dosage. And I think when we think about parole's capacity and looking at so many of the young individuals that are coming into the department now, they're coming in, I believe, with the right attitude. I think where the bump in the road is coming in is some of their superiors are still from the old regime. and some of their superiors still have battle wounds from their era of when they were not supported by their superiors when certain things took place. And they're not trying to get put on the front page news. You know, Wayne, they're not trying to do that. Let's be real. When you work for state government for 15, 20 years and you only have a few years left and you can see the pie in the sky, you're not trying to let somebody ruin all of that. And it's not fair that we have to put the threat to public safety versus I just don't like you versus I can help you in the same pot. Those three things, it's like oil and vinegar trying to get together, and we know that doesn't work. You know, you got to keep shaking it in order for it to stay, you know, together. And I think that the parole staff have what it takes to do this. The leadership that's there right now, Anna Enright, when I was the statewide director for reentry services, Anna worked under me. She knows her work. And I've said this in several forums. Stacey Dorsey worked under me. Detrell Howell, all of these key people worked under me. They know the work. They can give the information to the parole staff. They know the community-based resources. I've been knowing Stanley, and Stanley been knowing me when my hair was black, and I knew Stanley when Stanley had hair. So we've been doing this for a very long time. You know, so we know what needs to be done. The issue that exists, I believe, is that there is no one giving them what they need to stand on solid ground to make these decisions. Because when we take someone, as they would give an example, who has a substance abuse problem, there needs to be a think tank put together with OASIS. What do you do with the person who has exhausted all possible treatment modalities and may choose to still engage in substance abusing behavior? Nobody wants to still just get high. People think that, oh, they just want to get high. They don't want, no, that's not true. That is not true. They need other options. They need other alternatives. They need other environmental things. And I just think that what we have to do is sit with the right parties to get the right processes together and stop thinking that everything is a one size fits all. However, we have to, as I learned in Albany, we have to change the car tires as the car is moving. We need to put less is more into action. Because if we look at the COMPAS scores and those who are already reporting quarterly, let's move them on and out. That we don't have to do one big dose at one time. Let's move it slowly. But we have to get it moving, because the way we moved the reentry model forward was we did it slowly, and as we moved slowly and they saw results, more and more parole officers, more and more staff bought into it. But I believe parole has what it takes to do this. I think the staff they will buy into it. I think we just have to present it. We have to show them. As I said when I wrote something in the chat, we're not coming at their jobs. This is not about their jobs. This is about supporting them as they're trying to do their job. It's about reducing their caseloads so that they can focus on those who need the help. The people that you saw on the earlier panel, like Donna and the other gentleman, I think his name was Glenn, they didn't need all this micromanaging. They needed it at the beginning. And I think that was the 2015 Pew report said that there was something what we call overconditioning. And it also said that as much as we want to try to help, we got to let them, go, let them do, because when community supervision is over, it's over. Why not slowly transition them out, give them the less is more model, and let us move forward?
Thank you. And so, Stan, you heard Vonda talked about giving them what they need. And you're in the business of giving them what they need, right? And we know for many people, parole doesn't lead to a successful reentry. And in some cases, it may even be affirmatively preventing successful reentry. Now, the programming. tell me, what does that look like in practice? And how can these reform policies help empower you in your work to move individuals successfully out of the system?
Well, thank you for that, Wayne. First of all, I think we have to recognize that in New York, we have a pretty rich network of service providers ready and willing to engage on this issue. What we haven't had is the political will to invest in services as opposed to investing in punishment. We have far too long been on automatic pilot where everything looks like a nail and then we treat it as such and we hammer it. And that is about parole violations. And that's not speaking to the parole officers or those who work in the system. That's speaking to the system itself. And so what we know, one of the things we do at Fortune, we provide a range of services for people: reentry housing, licensed mental health treatment, licensed substance abuse, employment, retention, family reunification, HIV/AIDS case management, care management, healthcare, because we know those elements are critical for someone to rebuild their life after incarceration. And no one comes home saying, I can't wait to go back to prison. People come home with a degree of hope that hope gets dashed, whether it is the over conditions as Vonda talked about, or whether it is rejection after rejection, whether it is never being seen other than the number that you had, your DIN number and your conviction. And as a society, we need to begin to make changes. We need to get the political will to fundamentally change the system so that parole officers have reduced cases. And that's why less is more is so important. Reduce cases. We need to right size our investments from investing in incarceration and investing in services. We need to then make sure that we are reinvesting in the community. Part of what's happened in New York, you look at New York, closed Rikers, closed Rikers Reinvestment Committee, that's a commission that's looking at how do we reinvest the money as we reduce our reliance on mass incarceration to reinvest in communities impacted by mass incarceration and build out our social services so that people have access to services adequately, is the right way to go. We need to be doing a similar move on the state level. As the numbers have been coming down, we need to then reinvest those monies back into the social services safety net so that the men and women who are coming home are able to access services and stay connected to their community, so that there is a diversion part, like the less is more, talking about eliminating technical parole violations. No technical parole violations should go back to jail. We should be connecting them to services, employment, treatment, mental health. And so there is a wealth of social service networks in New York City that we just need to invest in, and we haven't done it. You know, I once heard that what government tries to do is to solve a massive problem with a nickel investment. But when it comes to incarcerating and doing trauma, imposing trauma on communities of color, we see our investments skyrocket, and we need to reverse that.
Okay, great. Thank you. And thank you to all of the panelists. And before I turn it back over to Kendra, you know, I always talk about the 4 R's of the criminal justice system: retribution, rehabilitation, reentry, and redemption. And as a system and as a society, we've got to answer the question, do we believe in redemption? Or does our desire for retribution outweigh our belief in the other 3 R's? And if so, does it make us more safe or actually less safe and more vulnerable? So thank you to each of my panelists. And Kendra, I turn it back over to you.
Thanks so much, Wayne. And I echo your thanks to our panelists, both from this panel, from the earlier panel, and to Judge Lippman for giving our keynote to start us off. Thank you for all of our attendees who stuck with us through some technical difficulties. I'm glad that you were able to stay here and rejoin us for this really important conversation at such a crucial time. I want to also just quickly thank our co-sponsors for today's event and encourage everyone to stay connected with the Justice Lab and with our co-sponsors as we continue trying to provide the best information to move parole forward in New York. Thank you all and have a great evening. Go enjoy the wonderful weather outside. Take care.